The Senate Judiciary Committee will come to order. And before I speak to the agenda before us today, I'd like to commend an article in the Washington Post this morning to the members of the committee. It comes as some surprise to many of us that the Bureau of Prisons maintains something like a bank, which has significant deposits by the federal prisoners, and that there's some history of difficulty in reaching those deposits for the payment of victim restitution and child support, among other things. I'm suggesting that any who are interested join me in sending a letter. Senator Grassley and I are going to ask the Bureau of Prisons for an explanation of this article. There are many questions that were raised in my mind based on previous assertions made by the Bureau of Prisons about prisoners' accounts. I was under the assumption that they were small amounts maintained, just basics for commissary or whatever at the prisons. It turns out that in many instances there are hundreds of thousands of dollars in these accounts from questionable sources. So I ask you all to take a look at it. We're going to send a letter to the Bureau of Prisons since this is obviously in our jurisdiction. And if you'd like to sign on to the letter, we'll give you that opportunity. We have 11 items on the agenda today, 9 nominations and 2 pieces of legislation. 6 of the nominations are listed for the first time and will be held over at the request of the minority. They include Tiffany Cunningham, nominated to the Federal Circuit, Margaret Strickland, nominated to the District of New Mexico, David Chipman, nominated to be Director of the Bureau of ATF, Jadot, nominated to be Director of the United States Citizenship and Immigration Service, Ann Milgram, nominated to be Administrator of Drug Enforcement, and Kenneth Polite, nominated to be Assistant Attorney General for the Criminal Division. We also have 3 nominees who are ready for a vote today. I'll address them and ask any other member who wishes to speak about their nominations to do so, and then proceed with the votes on the nomination. Then I'll address the 2 bills on the agenda today. First, we'll be voting on Judge Deborah Boardman, who's been nominated to a seat on the U.S. District Court for the District of Maryland. She's been found unanimously well qualified by the ABA and will bring real diversity to the court. She spent 11 years as a public defender, has worked as well in private practice, and done pro bono work. She has a strong support of her home senators, understands and respects the difference between advocacy and being a judge. Strongly support her nomination. We'll also vote on Lydia Grigsby, who's been nominated to be a district court judge for the District of Maryland. Many of us know her. She has only one questionable thing in her background. She worked for Chairman Leahy. She was previously a staffer on the Judiciary Committee, serving as Chief Counsel for Privacy and Information Policy under the chairman. Before that, Judge Grigsby spent 10 years at the Department of Justice as an Assistant U.S. Attorney. In 2014, the committee approved her nomination to be judge on the U.S. Court of Federal Claims by a voice vote, confirmed on the Senate floor by a voice vote as well. Since then, she's done an outstanding job. ABA has unanimously rated her well qualified. Judge Grigsby be the first African-American woman, first woman of color to serve as a district court judge in the District of Maryland. Finally, we'll be voting on Ronald Davis, nominated to serve as next director of the U.S. Marshal Service. Mr. Davis has spent almost 30 years of his life in law enforcement, 20 years with the Oakland Police Department, and then went on to serve for more than 8 years as Chief of Police in East Palo Alto. In East Palo Alto, he launched initiatives curbing gang violence and building community trust. Crime rates fell in the city. An article in the Palo Alto Weekly, published shortly after he started as chief, said for the first time in years there's a palpable sense of hope about the East Palo Alto Police Department. Shortly after, he was asked to lead the Justice Department's Office of Community-Oriented Policing Service, known as COPS. In this role, he oversaw hundreds of millions of dollars in grants to state and local police departments to hire and retain thousands of officers. In other words, Davis's leadership allowed police departments around the country to bring on more officers. Throughout his career, he's shown time and again a deep respect for law enforcement and a belief in the need for police reform, and he's shown us they don't need to be mutually exclusive. It's no surprise that he's garnered the support of virtually every major law enforcement organization: Fraternal Order of Police, National Sheriff's Association, Federal Law Enforcement Officers Association, and numerous others. They recognize, as do I, the vast qualifications he has to lead the U.S. Marshal Service. With that, I turn to Ranking Member Grassley.
Yeah. I'm going to support two of the nominees, Judge Grigsby for Maryland and Ronald Davis, head of the Marshal Service. I think both are very well qualified. The third nominee, Judge Boardman, I want to oppose and will. Currently magistrate judge in Maryland. Before that, spent most of her career as a federal defender. As I've said many times, we need to carefully scrutinize these federal defender nominees because the left seems to think that they'll rule in a certain way. But beyond that, as I mentioned at the hearing yesterday, I have concerns that nominees whose careers are so defined only by criminal defense may not be up to the task of serving as a generalist judge. Unfortunately, I think this nominee falls into that category. At her hearing, she was asked basic questions about constitutional law by Senator Kennedy, as were many, many nominees under President Trump. I don't think she passed Professor Kennedy's exam. I have no doubt that she'd have excelled at questions of criminal procedure, but that's only one part of the judge, along with basic constitutional law. Unlike circuit judges, district judges don't always have the luxury of cleaning up their legal views in writing after the fact. I'm therefore going to vote against Judge Boardman. We're also advancing two bills that were held over, the Prohibiting Punishment of Acquitted Conduct Act and the First Step Implementation Act. I'm a co-sponsor of these bills. They're very specific and very tailored reforms, and they're bipartisan. And they seek to strike a balance in our criminal justice system of promoting public safety and ensuring fairness. With that in mind, I want to talk about an important consideration of these bills, and that deals with the subject of violent crime. There's an unfortunate trend of increased violent crime across the country. Iowa isn't immune to that trend. I don't take this issue lightly. As recent as last week, I wrote a letter to our Attorney General asking how he plans to combat violent crime while simultaneously moving funds away from law enforcement, which he said he was doing. So I want all my colleagues to know violent crime ought to be on everybody's mind, as it is mine, as we consider these bills. In drafting and reviewing them, I sought to strike a balance of protecting public safety but being smart and fair. I think these bills do that. But my door is always open to discuss with any colleagues how we can promote justice and fight violent crime, and I think the chairman of the committee, as well as I, would be happy to work with people as these bills proceed to the Senate floor. So I welcome the opportunity to work with my colleagues on further refinements. We should be careful and intentional, respectful and open-minded. And in the context of criminal justice bills, we must be balanced. Thank you, Mr. Chairman, for these bills, moving them forward and leading the effort to discuss their merits and possible amendments.
Thank you, Senator Grassley. Are there members who wish to speak to the nominations? Senator Leahy, I believe, was first.
Thank you.
White House wants to speak to Davis.
I'm delighted to see Lydia Grigsby before us, and as you mentioned, Mr. Chairman, she had great service here in this committee. I know she joined my Judiciary Committee staff as Privacy Counsel in 2004, and then became Chief Counsel for Privacy and Information Policy. She was instrumental in the enactment of a number of bills I authored, including the Open Government Act of 2007, and enacted Senator Cornyn and I worked closely on the Open FOIA Act of 2009, and which passed overwhelmingly. And her work with both Republicans and Democrats on that was so essential. She routinely demonstrated the qualities we all want to see in our federal judges. ability to sort through information impartially, a command for communicating effectively to a variety of audiences in written and oral form. But most importantly, and what struck me the most important, a deep commitment to the rule of law. Her professional prowess matched by her personal qualities. She always took time to ensure that junior members of my staff were given opportunities to work alongside her in the impressive work she's doing. Her willingness to treat all staff, regardless of seniority, with respect and kindness was one of her defining qualities and would be as a judge. I think she possesses the right set of skills, of life experiences, judgment, and temperament to excel as a federal judge. Like many on here, I've appeared before many judges in a prior career. This is somebody that everybody who appears there, plaintiff or defendant, can feel they have a real judge. So thank you very much, Mr. Chairman.
Any other senators wishing to speak to the nominees? Senator
Mr. Chairman, I know
Whitehouse.
you'd like to proceed with the votes, so why don't we do that? And if I could be recognized at the conclusion of the votes. It's a related comment, but I intend to vote for all the nominees.
So if no one else wants to speak to the nominees, on favorably reporting the nomination of Deborah Boardman to be U.S. District Judge for the District of Maryland, the clerk will call the roll.
Mr. Leahy.
Aye.
Mrs. Feinstein. Mr. Whitehouse. Ms. Klobuchar. Mr. Coons. Mr. Blumenthal. Ms. Hirono. Mr. Booker. Mr. Padilla. Mr. Ossoff. Mr. Grassley.
No.
You could just start
Mr.
moving
Graham.
this earlier and earlier. You know,
Pass.
8 a.m., 7 a.m.
Mr.
Because you're
Cornyn.
No.
fundraisers. And then
Mr. Lee.
No by proxy.
Mr. Cruz. Mr. Sass.
No by proxy.
Mr. Hawley.
No by proxy.
Mr. Cotton.
No by proxy.
Mr. Kennedy.
No by proxy.
Mr. Tillis.
No.
Mrs. Blackburn.
No by proxy.
Chair Durbin.
Aye.
Chair Durbin, the votes are 11 yeas, 10 nays.
The nomination will be favorably reported to the floor. Moving to the next nomination, on favorably reporting the nomination of Lydia K. Grigsby to be U.S. District Judge for the District of Maryland, the clerk will call the roll.
Mr. Leahy.
Aye.
Mrs. Feinstein. Mr. Whitehouse. Ms. Klobuchar. Mr. Coons. Mr. Blumenthal. Ms. Hirono. Mr. Booker. Mr. Padilla. Mr. Ossoff. Mr. Grassley.
No. Aye.
Mr. Graham.
Aye by proxy.
Mr. Cornyn. Mr. Lee.
No by proxy.
Mr. Cruz. Mr. Sass.
No by proxy.
Mr. Hawley.
No by proxy.
Mr. Cotton.
No by proxy.
Mr. Kennedy.
Aye by proxy.
Mr. Tillis.
Aye.
Mrs. Blackburn.
No by proxy.
Chair Durbin.
Aye.
Chair Durbin, the votes are 16 yeas, 6 nays.
The nomination will be favorably reported to the floor. Finally, on favorably reporting the nomination of Ronald Davis to be Director of the U.S. Marshal Service, the clerk will call the roll.
Mr. Leahy.
Aye.
Mrs. Feinstein. Mr. Whitehouse. Ms. Klobuchar. Mr. Coons. Mr. Blumenthal. Ms. Hirono. Mr. Booker. Mr. Padilla. Mr. Ossoff. Mr. Grassley.
Aye.
Mr. Graham.
Aye by proxy.
Mr. Cornyn. Mr. Lee.
No by proxy.
Mr. Cruz. Mr. Sass.
No by proxy.
Mr. Hawley.
No by proxy.
Mr. Cotton.
No by proxy.
Mr. Kennedy.
No by proxy.
Mr. Tillis.
No.
Mrs. Blackburn.
No by proxy.
Chair Durbin.
Aye.
Chair Durbin, the votes are 14 yeas, 8 nays.
Nomination will be favorably reported to the floor. At this point,
Could you give us the vote count
I think the clerk announced it, but we'll do it again, please.
14 yeas, 8 nays.
Thank you. Senator Whitehouse, I'm sorry, do you seek recognition?
Yeah, I just wanted to repeat what the committee has heard me say before, which is to express my concerns about the persistent black hole over at the FBI and the Department of Justice into which requests from Congress go. This was, frankly, a problem in the Obama administration. It flourished during the Trump administration, and we are pursuing investigations into exactly what the hell went on and why no QFRs would be answered, questions that we sent in letters would be ignored, and so forth. I'm not seeing, frankly, great improvement in this administration yet, although I know that they're newly in place, so I still have hope. But there is a bipartisan letter that Senator Kennedy and I have into the U.S. Marshal Service, and I'm going to want some assurance that the Marshal Service is not going to send its response into that black hole before we proceed with Mr. Davis on the floor. Nothing against him. This is an institutional problem of DOJ and the FBI seemingly having a blanket policy against answering committee questions.
Thank you very much, Senator. At this point, the first bill on today's agenda is S-601, Prohibiting Punishment of Acquitted Conduct Act of 2021, which I have introduced with Senator Grassley. The bill was held over at the last markup, and as I explained then, the bill does what it says. It would prohibit judges from using acquitted conduct as a basis for sentencing. The late Justice Scalia, joined by Ginsburg and Thomas, argued this practice is unconstitutional and, quote, has gone on long enough. Justice Kavanaugh made the same point on the D.C. Circuit, calling the practice, quote, a dubious infringement on the right to due process in jury trial. The Supreme Court has not addressed this issue yet, but we should not wait for them to end this practice. This bill does that. The bill has broad support. National Coalition Against Domestic Violence, ACLU, American Conservative Union, Association of Prosecuting Attorneys, Leadership Council on Civil and Human Rights, National Organization of Black Law Enforcement Executives, and others. Along with myself and Senator Grassley, this bill is co-sponsored by Senators Leahy, Lee, Booker, and Tillis. Senators Klobuchar and Ossoff have been asked to be added as co-sponsors, and without objection they will be. On behalf of myself and Senator Grassley, I offered a bipartisan manager's amendment. At the last markup, the amendment made changes in response to technical assistance provided by the Department of Justice. It was adopted without objection. Senator Grassley and I have been working with Senator Whitehouse to address a concern he raised at the last markup, and I understand he has an amendment to offer. Senator Whitehouse.
Yeah, I believe the chairman has the amendment and that it has been agreed to by all. So I'm happy to proceed. I intend to vote in support of moving this bill forward, but I have lingering concerns, and I'd like the chance at the chairman's convenience to express those concerns.
I want to thank Senator Whitehouse and his staff for working with us on trying to resolve this issue. Senator Feinstein raised similar concerns. I believe that we've addressed those at least temporarily, not the ultimate disposition of the bill,
Correct.
but at least to move it forward. I think
Correct.
We're prepared to do that. This amendment clarifies that the bill does not limit the rights of a victim under the Crime Victims' Rights Act. The amendment would not permit a judge to use a victim's testimony about acquitted conduct to increase a sentence. However, it does ensure that victims have a right to be heard and that judges can use victim testimony to increase a sentence regarding conduct for which a defendant has been convicted. And I urge my colleagues to support this amendment. We can pass it by voice unless there's a request for a roll call on the White House amendment.
Mr. Chairman, may I ask a question, please?
Senator Cornyn.
The way I read S-601, it's not true that testimony relative to a acquittal can be considered. It can be considered under your bill. It can only be considered to lessen the sentence, but not to increase it within the statutory range. Is that correct?
That's right. That's right.
So why would you consider testimony with regard to an acquittal to lessen the punishment within the statutory range, but not to increase it within that range?
It's my understanding that it would be unconstitutional to bar evidence that could be offered in mitigation, and that's the reason for the distinction.
Well, I don't understand a one-way ratchet, but thank you for confirming my reading of the bill. Thank you.
So let's first offer the White House amendment. All those in favor say
No,
aye.
I'd like a roll call vote.
Okay.
And if I can just understand, please, maybe I can ask.
Just to be clear, Senator Cornyn, this is simply the adding of the victims piece to the amendment. It's not
Right.
a substantive matter. Be convenient, I think if we could do a roll call vote, but it's
Well,
obviously your call.
Maybe, let me just try this. So the Crime Victims Bill of Rights would apply to this, this provision? Is that what the amendment does?
Yeah, it says nothing in what we're doing would undo anything in the crime victims' rights.
So crime victims can be heard, but what they say will not be considered.
I think it's usually considered. I've never seen a courtroom in which the judge didn't consider what the crime victim stood up to say in the courtroom.
But I thought that's what the purpose of the bill was, to prohibit testimony with regard to acquitted conduct. And if you say that the crime victims can speak, but that the judge can't consider it, am I misunderstanding what?
I think you are.
I am. And could you clarify that for me?
It seems pretty self-explanatory that the crime victim can make their statement and the judge can consider it.
Well, Mr. Chairman, it sounds to me like we're saying that we can pretend to let the victim speak, but the judge can't hear it or consider it. And I don't think it's makes any sense, and I do think it puts blinders on the court during a sentencing, and at a time when the judge should be able to have a plenary ability to consider conduct, pattern and practice, history.
If I could inquire of Senator Whitehouse, I share Senator Cornyn's concerns, and I guess I would ask Senator Whitehouse, I agree that your amendment says that the crime victim can give their testimony, but I don't see where it says the judge can consider it, and given the operative text of the bill, it would seem to me the judge can't consider it, that the victim can testify, but the judge is prohibited from considering what the victim says. Is that, if your intention is otherwise, I'm not sure this language accomplishes.
I'm not sure if this clarifies it, but there's a distinction that we're making between acquitted conduct and convicted conduct. If it is acquitted conduct, then we're saying that the victim cannot testify as to the acquitted conduct to increase the sentence. However, if it is convicted conduct, assume two different counts in this situation, one guilty, one not guilty. When it comes to convicted conduct, the crime victims' rights are still preserved to testify at the sentencing hearing.
So I would say with Chairman Durbin's clarification, it appears even more limited than what Senator Whitehouse is looking for, because if I understand Chairman Durbin's clarification correctly, the victim would take the stand and begin to testify about what happened to her, what happened to him. And if it ventured into the arena of acquitted conduct, am I understanding the chairman correctly that you would envision the judge saying the victim is not allowed to discuss that? Because what you just said there wasn't just the judge couldn't consider it, you just said the victim couldn't even testify as to acquitted conduct.
There's nothing that restricts, we make it clear with this amendment, nothing restricts the victim's testimony at the sentencing hearing. Nothing restricts the victim's testimony at the sentencing hearing.
But can the judge consider it?
Not to increase the sentence for acquitted conduct.
So I think we're
That's
left
what-
where the victim can say whatever she or he wants, but the judge is
Well,
prohibited from considering.
if they've been acquitted of a certain charge, then that's the premise of the whole legislation, is that should not be held against them for sentencing purposes. Nothing restrains the victim from testifying at the sentencing hearing under the law for any conduct which the jury or judge has found to be convicted conduct. two distinct things.
So can the victim testify as to acquitted conduct?
Not, it can testify, but not to increase the sentence.
So this would make it illegal to consider that portion of the victim's testimony?
It would draw this distinction between acquitted conduct and convicted conduct.
Mr. Chairman, may I ask
Sure.
another question, please? So let's say hypothetically that someone is charged with multiple counts of sexual assault on a child, but that for some reason the jury decides that one of those counts they decide to acquit because they don't think the burden of beyond a reasonable doubt has been met. But as to the other counts, they convict. How would the judge parse what testimony could be considered and what testimony could not be considered during the sentencing?
It turns our Constitution on its head, I think, to suggest that judges should be able to impose a sentence based on acquitted conduct. Let me use an example that may be clearer. If there's a count for murder and a count for sexual abuse, and the jury acquits the defendant on the murder count, but finds them guilty on sexual abuse, then the victims could testify on that conduct that they've been convicted of sexual abuse when it comes to sentencing. But as to the count that the jury has found not guilty, the same cannot be true. They can say what they wish, but it cannot be used to increase the sentence of the defendant.
Well, like a good lawyer,
Chairman.
Mr. Chairman, you've changed my hypothetical.
For clarity.
No, I would say for advocacy purposes. So if a single individual is charged with multiple counts of sexual assault, but the jury acquits on one of them, how is the judge supposed to figure out what he or she can consider and what he or she cannot consider under the legislation?
Well, I think it's pretty clear. And let me tell you that in your own state, it's been recognized the importance of ensuring that the standard of proof beyond a reasonable doubt is met before conduct can be considered at sentencing. Under the Texas Code of Criminal Procedures, it specifically bars consideration of other bad acts or offenses unless the sentencing judge or jury finds beyond a reasonable doubt that the defendant is responsible for those acts. Defendants in a federal court, I think, should have the same constitutional protection that your state offers.
Well, you know the difference. I know you know the difference between state and federal law. So
There is a
the state legislature makes state law. The federal Congress is the one responsible for federal law. And I ask a hypothetical, and I just think that this presents the judge with an impossible burden of trying to parse what she or she can or cannot consider in a sentencing phase, and I just don't think it's workable. I do think to the extent it can be considered to lessen the sentence within the guidelines, but not to increase it also within the guidelines, it's a one-way street.
Mr. Chairman,
Senator Whitehouse.
perhaps I can help move this along a little bit, because I think the conversation has strayed beyond the amendment, which is a fairly simple one that I think we could all agree to, and into the underlying merits of the bill. And what I've told the chairman I'm prepared to do is to vote to move this bill forward, but that I am not satisfied with it yet, and we're going to have to work more to try to solve the problem. I appreciate very much that the victim has been recognized in this bill, because at a sentencing, it's not just the criminal in the courtroom, it's also the victim, and I think that recognition is important, and I appreciate the chairman agreeing to this amendment, and I think it's pretty non-controversial. As I said, I intend to vote to proceed, but with the following hesitations. Where you're dealing with acquitted conduct, I am very happy to say that the judge cannot shift the guidelines, cannot change the guidelines range based on so-called acquitted conduct. I agree with that. That is part of this bill. I agree with it. I'm a little bit troubled by whether or not a judge should be able to depart from the guideline range based on evidence of acquitted conduct. I believe quite strongly that a judge ought to be free to sentence within the guideline range based on acquitted conduct. And there are several reasons for that. The first is that anybody who's been to a sentencing knows what a federal judge is looking at is a pre-sentence report that lays out the case for how the criminal, the defendant, should be sentenced. And the whole pre-sentence report is unsworn hearsay that has been assembled by probation and parole to provide a basis for the sentencing process. If you can look at that kind of stuff in sentencing, it's really hard to understand why a judge shouldn't be able to look at testimony that he or she heard in the courtroom. And while we call it acquitted conduct, that's actually not what happens in a criminal trial. What happens in a criminal trial, the question is, did the conduct of the defendant meet the elements, all the elements of this particular crime beyond any reasonable doubt? And the fact that at the end of the day the jury is not convinced of that does not mean that the defendant did not do the conduct. And it does not mean that the jury didn't believe that the defendant did the conduct. They could have believed that an element was missing, perhaps the requisite mens rea. Or they could have believed that, I lost my note here. There we go, sorry. They could have believed that the government just failed at its proof. It is not unheard of for a juror to believe, you know, I think he did it. But I don't think the government proved that he did it beyond any reasonable doubt. I have a reasonable doubt, and therefore I'm going to vote not to convict. So to lay all of that back on a finding presumed of the jury that they find as a fact that the defendant didn't do the underlying conduct, I don't think is supportable. And there's an entire legion of case law out there of people who either aren't convicted or have charges dismissed under the criminal code, and then the victim sues civilly. And the case goes forward. And the victim can prove by a preponderance of the evidence or by clear and convincing evidence, if necessary, that they were injured in the way that they have alleged. So the conduct and the test of whether the conduct actually happened always survives a criminal verdict of not guilty. And to allow a judge, to prevent a judge from looking at that for purposes of sentencing within the guidelines seems very anomalous with the defendant or the victim's ability to proceed to court and pursue that case as a civil matter and seek damages for the harm that was committed. And it also seems anomalous with the pre-sentencing report, which has essentially very little evidentiary basis, but is the standard for going forward. So that's where I am. And if you would be comfortable leaving this amendment to go, let's keep having this conversation about how to get this right with respect to the underlying bill. I'm going to vote to move it forward. I'm sold that you shouldn't move the sentencing guidelines based on so-called acquitted conduct. I will put that into quotation marks as a phrase. I'm willing to be convinced, although I have a hesitation about a departure based on acquitted conduct, but I really don't see why in the whole realm of information and evidence that a sentencing judge is allowed to look at within the guidelines, we should pick this one particular thing and take it out of the view of the court when the law reflects the merit of allowing people to look at the substance of it in virtually every other way, including letting a civil case go forward. Nobody can move to dismiss a civil proceeding on the ground that they were acquitted of a crime for the same act. You just can't do that. So that's where I am.
Senator Cruz.
Mr. Chairman, I find myself agreeing emphatically with Senator Whitehouse.
Well, in that case, I will have to rethink my position.
Which may in fact be a sign of the end times and cause both of us to reconsider what we're doing. But I think what Senator Whitehouse said was quite persuasive, and he may have laid out in his most recent comments a potential path forward to getting significant bipartisan agreement on this provision, which is Senator Whitehouse drew a distinction between considering acquitted conduct for departing above the guideline range versus considering acquitted conduct when a judge is assessing where within the range to sentence a defendant. So if the range is 48 to 60 months, the judge can consider a host of events. And the dissent from denial of certiorari that Justice Scalia and Justice Thomas wrote made the very same distinction and said there are constitutional problems with changing the range to which the defendant can be sentenced, but that there were not constitutional problems with considering the so-called acquitted conduct within the range of what could already be permissibly imposed for the convicted conduct. Now, I am told there is an amendment that was filed from Senator Cotton. Senator Cotton's staff helpfully highlighted it to me that I guess, if I can read this, is ALI 21888, where Senator Cotton's amendment, on reading it, says that you can't use acquitted conduct to depart upwards, but by necessary inference, you can consider it when the judge is determining where to sentence within the range. At least as so far as I'm concerned, if Senator Cotton's amendment were added to this bill, I could vote for the underlying bill, and that may assuage the concerns of a number of senators.
Do they want me to do that?
A point of question, Mr.
Senator Feinstein.
Oh. Doesn't this continue throughout the bill or not?
I'm sorry, Senator, I didn't understand that.
Well,
Okay, what am I calling this? Do I have an amendment number on it?
it says, "The amendment made by paragraph 1 shall apply only to a sentence imposed on or after the date of enactment." Oh, that's not It's my understanding that the amendment limits the prohibition on a judge's consideration of acquitted conduct to sentencing. Is that correct?
Yes.
Okay, and only applies the prohibition to situations where a judge has already departed from the sentencing range that is provided in the federal sentencing regulations. Is that correct?
I believe it is.
So this is a limited amendment.
Yes. This has turned out to be an interesting debate, and I think there is more commonality and agreement than may be apparent at this moment. I'm going to ask that this bill and the amendments be withheld from today's consideration because my staff was having me offer an amendment which sounded like it was an agreement with Senator Cruz, which obviously I want to think about. That was said in jest. Senator, I think what you've just suggested as Senator Cotton's amendment is similar to a second-degree amendment my staff has prepared. I think it's important for us to get this together if we can. So I'm going to, with the permission of the committee, withhold this matter for the time being.
Thank you.
Chairman, may I make one more comment?
Yes, of course.
I urge consideration by my colleagues of the amendment that I've just given to Senator Cruz, which is ALB 21958. And what it provides is that in determining an appropriate sentence, a court of the United States shall not consider acquitted conduct under this section for the purposes of determining the appropriate sentencing range pursuant to the United States sentencing guidelines, which is what we're talking about, shifting the range, or to sentence a person outside of that sentencing range, i.e., as a departure from the guidelines. But it would allow the judge to do what judges have done since time immemorial, which is have discretion to sentence within the guidelines for a whole wide variety of conduct. And I don't want to speak for what other support that may have on anywhere else, but I think that's something to look at and could easily forge a compromise on this matter.
So, Senator Whitehouse, I think that moves the ball forward considerably, and so what I would suggest, the chairman just said you're going to delay consideration of this matter?
If there's an agreement here, it sounds like Senator Whitehouse is proffering an amendment, which is what you have described when it comes to departure from sentencing guidelines.
So I think that does a lot of it. In a perfect world, an additional sentence making clear that this does not constrain what you consider when sentencing within the range would enhance the clarity of it. Right now, that's probably there by silent inference, but you'd probably have litigation back and forth on, well, they didn't include that sentence, what did it mean?
Here's what I would like to do, Senator Cruz. I owe the chairman and his team an apology, and I also owe my staff an apology because my intervention on this bill last time was a surprise attack to everyone. You've all been in the circumstance that I was in then, which is that I was really only reading the memo thoroughly for the first time when I sat down in the hearing. I'm probably not the only senator that's ever been in that experience. And then I realized I had a problem. So I surprised the chairman, which was wrong of me, but that was where the position I was in, and his staff, which I apologize for. And I put my staff person in a terrible position because she said, I haven't heard any problems from the senator on this. I think we're good to go. So what I would like to do as a courtesy to our chairman is to get this bill moved out today. I think that this amendment does it, my amendment as amended with the provision that we just discussed. And I think we can agree to further conversation as the bill moves to floor consideration. But I think it would be a helpful start and good for committee to just let this thing go with that amendment and try to resolve any lingering issues that the Senate or others may have as it approaches floor consideration. So I would request that of my colleagues, with the chairman's permission.
I'm prepared to do that. The suggestion, I believe, by Senator Whitehouse is the original amendment by Senator Whitehouse would be amended by the second-degree amendment and then offered and accepted as part of the underlying bill both. And the matter would be reported from the committee but would stay on the Senate calendar until such time as we add perhaps the sentence that Senator Cruz has just suggested. We'll see if that is an avenue to bipartisan support.
Yeah, with that agreement, I'd be prepared to go forward.
Is there anyone else? Senator Cornyn?
I'm sorry, this is moving pretty quickly and gets a little confusing. Senator Whitehouse, are you saying that we ought to have an affirmative statement that the court can consider acquitted conduct for purposes of sentencing within the guidelines?
That is not what the amendment says. It simply limits the restriction on using acquitted conduct to shifting the guidelines and to departure. But Senator Cruz has proposed adding it and has said that it's probably implied in the bill. I would have no objection to that clarification, but what I would like to do is to allow the chairman to move the bill, and hopefully with bipartisan support, and work out those details with everyone, because I think there's a landing ground here that can have broad bipartisan support, and I'd like to get there, but I'd like to get the bill moving because of the position I put the chairman and the committee staff into.
Well, Mr. Chairman, I think I'm persuaded by the conversation that Senator Whitehouse and Senator Cruz is having, but I think the better course would be for us to come back once this is nailed down, rather than to pass a bill out of the committee that's not ready for prime time.
Any other comments on the bill or amendments? I'm going to go ahead and offer the motions. We're going to see where the committee is on this measure. And I believe the first consideration would be the second-degree amendment offered by Senator Whitehouse. Is that correct?
That is correct, sir.
All right. I can call the roll or do it by voice vote. We will have a.
Mr. Chairman, could you clarify what the amendment is that we're voting on?
The amendment number is ALB 21958. And
That's the magic language for purposes of determining the
it adds the following language.
side of the range.
Thank you. I got it.
You have it? Senator Cornyn, you have it?
We're okay.
ALB 21958. So the question is on the adoption of the second-degree amendment by Senator Whitehouse that I have just described.
Those in favor say aye.
Those in favor say aye.
Aye.
Opposed?
No.
Opinion of the chair, the ayes have it. Now the question is the White House amendment as amended. All those in favor say aye.
Aye.
Those opposed, no. Opinion of the chair, the ayes have it. And now the question is on the bill itself. The clerk will call the roll on 601 as amended.
Mr. Leahy.
Aye.
Mrs. Feinstein. Mr. Whitehouse.
Aye, and with due appreciation.
Aye.
Mr. Coons. Mr. Blumenthal. Ms. Hirono. Mr. Booker. Mr. Padilla. Mr. Ossoff. Mr. Grassley.
Aye.
Mr. Graham.
Aye by proxy.
Mr. Cornyn.
No.
Mr. Lee. Mr. Cruz. Mr. Sass.
No by proxy.
Mr. Hawley. Mr. Cotton.
No by proxy.
Mr. Kennedy.
No by proxy.
Mr. Tillis.
Aye by proxy.
Mrs. Blackburn.
No by proxy.
Chair Durbin.
Aye.
Chair Durbin, the votes are 16 yeas, 6 nays.
The bill will be reported favorably to the floor with the assurance of the chairman that before any action is taken on the floor, we will have addressed this again, Senator Cruz, Senator Whitehouse, myself, and Senator Cornyn, and any others, to see if there is additional language that clarifies our intent. Agreed? Understood? Fine.
Agreed, and I thank the chairman for his patience with this.
Next up is S 1014, the First Step Implementation Act of 2021, which I've introduced with Senator Grassley. As I explained in the last markup, this bill should be familiar to most. All of these provisions were in Sentencing Reform and Corrections Act, which the committee approved in 2015 on a bipartisan 14-5 vote, again in 2017 on a 16-5 vote when Republicans were in the majority. The bill allows judges on a case-by-case basis to retroactively apply the First Step Act sentencing reform to sentences imposed prior to the First Step Act. The bill also gives judges broader discretion on a case-by-case basis to apply the First Step Act safety valve provision to sentence low-level, nonviolent drug offenders who cooperate with the government below the mandatory minimum. Additionally, the bill allows courts to reduce sentences imposed on certain qualified juvenile offenders who've served more than 20 years, a provision originally authored by Senators Cornyn and Whitehouse. The bill also provides for the sealing and expungement of records of nonviolent juvenile offenses, requires the Attorney General to establish procedures ensuring that only accurate criminal records are shared for employment-related purposes, provisions authored by Senator Booker, the chairman of the Criminal Justice Subcommittee. Again, I want to especially recognize Senator Lee, who I believe we started this journey together many years ago, and who championed the provision limiting the unfair stacking of penalties for 924C gun possession offenses. He has often cited the case of Weldon Angelos, a Utah man who received a 55-year sentence for selling marijuana, as an example of sentencing laws requiring punishments beyond the crime. Just as in 2015 and 2017, this bill has unusually broad bipartisan support from the American Conservative Union, Freedom Works, law enforcement leaders, Association of Prosecuting Attorneys, Leadership Conference, and many more. These were important reforms when this committee approved them in 2015 and 2017, still needed. This time, we should be sure they are enacted into law. Senators Leahy, Whitehouse, Klobuchar, Booker, and Ossoff have asked to be added as co-sponsors. of this act. Without objection, they will be. And on behalf of myself and Senator Grassley, I will offer a bipartisan manager's amendment. Without objection, that manager's amendment will be adopted. I understand Senator Lee has an amendment to offer.
Thank you, Mr. Chairman. I'd like to offer Lee Amendment HEN 21803, which will strengthen the First Step Implementation Act by ensuring that juveniles convicted of serious violent felonies will not be eligible for relief under the bill's provisions, allowing for the sealing and expungement of certain crimes committed by juveniles. Now, some members of this committee will remember that the definition of a serious violent felony was carefully negotiated during bipartisan discussions surrounding and leading up to the passage of the First Step Act. It's a concise, clear way of describing crimes for which expungement or the sealing of records would not be appropriate. This language isn't remotely controversial. In fact, it's used several places earlier in the same bill. Now, specifically, my amendment clarifies that juveniles who commit these crimes, that is to say serious violent felonies, cannot have their records sealed or expunged. Without this addition, the Act's language would not cover serious violent crimes like attempted murder, carjacking, and extortion. My amendment also addresses concerns that some of our colleagues have raised regarding the sealing or expungement of crimes involving firearms. Both criminal firearm use and possession are covered under the definition of serious violent felony. My amendment strengthens the bill. It excludes serious violent offenses and provides more clarity to the courts. And so I urge my colleagues to support it.
Thank you, Senator Lee. I support the amendment. I think it simply replaces exclusions with currently in the law with terrorism or any serious violent felony, as that term was defined in the First Step Act. And I urge my colleagues to support the Lee amendment. Are there any other comments on the Lee amendment? All those in favor say aye. Aye. Opposed, no. The Lee amendment is adopted. And as to the manager's amendment, without objection, it too will be adopted as amended by Senator Lee. Does any senator seek recognition to speak or offer an amendment to the bill as amended by the manager's amendment and Senator Lee's amendment?
Mr. Chairman.
Senator Cornyn.
Mr. Chairman, I'd like to call up my amendment ALB 2198314C. This amendment would preclude the most violent offenders, those who've already been sentenced based on the law and the books at the time, from having their sentences retroactively reduced or slashed in half. It only would apply to the most violent offenders and require all prisoners who may be eligible for retroactive sentencing to undergo a risk assessment. This is a common sense step. With rising crime rates across the country and the need to protect victims of all offenses, but particularly those involving violent crime, I think it's bad policy for us to release inmates back into communities who are violent and certainly without knowing the risk level they pose to their community. When we negotiated the First Step Act, the retroactive application of the mandatory minimums was something that many of our colleagues fought hard against. I see a lot of value in holding those who brandish and discharge firearms, for example, and those who generally use extreme violence against innocent victims accountable to the fullest extent of the law. The First Step Implementation Act has a number of problems, but it's clearly a bridge too far to give such a sweetheart deal to the most violent offenders whose sentences have already been finalized by the courts and all of their appeals have been exhausted. I am committed to sensible criminal justice reform. I think my record reflects that. But this bill undermines the will of previous Congresses and also violates the spirit of the agreement we previously made when we negotiated the First Step Act over multiple years. So I would urge adoption of my amendment.
Thank you, Senator. Your amendment would prohibit individuals who've ever been convicted of a crime of violence, a technical term in the criminal code, from petitioning for retroactive sentencing relief even if the crime took place decades earlier. A crime of violence includes any offense that has an element has as an element the use, attempted use, or threatened use of physical force against a person or property of another, and can include simple battery or property crime. The First Step Implementation Act's retroactive application does not automatically reduce a single sentence. I want to make that clear because I think there may be a misunderstanding here. It simply allows individuals to petition courts for an individualized review of the case. A judge is required, once that petition is made, to review all circumstances in a case, including public safety, criminal history, nature of the offense, before granting or denying any petition. These changes are necessary to ensure that individuals who are still serving sentences under old laws that Congress has changed because they are unfair have a chance to petition for First Step Act sentencing reform. We learned from the Fair Sentencing Act and the First Step Act that this can be done safely. You'll recall the genesis of this whole conversation was the war on drugs and the disparity between crack cocaine and powder cocaine, which led, sadly, to dramatic increases in incarceration in our federal prisons, particularly minority prisoners, and also had literally no positive impact on ending the scourge of drug abuse. We learned the hard way that we needed to change it, and that's why the First Step Act was introduced in the first place. The Sentencing Commission found that those who received sentence reductions based on the Fair Sentencing Act had recidivism rates that were virtually identical to those who did not receive reductions. Bureau of Prisons reported in December that rates for those released early under the provisions of the First Step Act are actually lower than traditional rates. The point that I'm getting to is this: when we take a look at the record of those who were released under the existing law without the Cornyn Amendment, we find that the results are as good or better than those that have happened before. This amendment would exclude retroactive sentencing, would also exclude retroactive sentencing relief for individuals not designated as low or medium risk. I think Senator Cornyn has asked us with his amendment to re-engage in a debate which I thought was resolved on a bipartisan basis. I urge my colleagues to oppose it.
Mr. Chairman, may I respond?
Yes, you may.
Well, Mr. Chairman, it was negotiated in the First Step Act, and it was excluded, and the chairman's bill would add. It's hard to hear. I'm sorry. I would say there were previous negotiations under the First Step Act, and this idea of retroactivity for people who brandish and discharge firearms in the commission of a crime, they were excluded for a purpose, because the First Step Act was supposed to be about nonviolent offenders. The First Step Act was supposed to be about doing scientific, or as close as we can come, scientific risk assessments of the danger to the public if these individuals receive a relief under that law. I think, given the fact that violent crime has risen dramatically in America in the recent months, ought to indicate caution is called for here, and particularly at a time, I know, when Senator Schumer has said he wants to bring a bill to the floor to limit the constitutional rights of law-abiding citizens under the Second Amendment, to then turn around and release retroactively people who've been convicted of brandishing and discharging firearms in the commission of a violent crime.
Nonviolent drug offenders.
This is a dystopian proposition, to my mind. I'd urge adoption of my amendment.
If there's no further discussion,
Like a roll
questions
call.
on the adoption of the Cornyn Amendment, and the clerk will call the roll.
Mr. Leahy? No. Mrs. Feinstein? No. Mr. Whitehouse?
No.
Ms. Klobuchar? No. Mr. Coons? No. Mr. Blumenthal? No. Mr. Rono? No. Mr. Booker? No. Mr. Padilla? No. Mr. Ossoff? No. Mr. Grassley?
No.
Mr. Graham?
I vote proxy.
Mr. Cornyn? Aye. Mr. Lee? Aye. Mr. Cruz? Aye. Mr. Sass?
I vote proxy.
Mr. Hawley? Aye. Mr. Cotton?
I vote proxy.
Mr. Kennedy?
I vote proxy.
Mr. Tillis?
I vote proxy.
Mrs. Blackburn?
I vote proxy.
Chair Durbin.
No.
Chair Durbin, the votes are 10 yeas, 12 nays.
The amendment is not agreed to. Are there any further amendments? Senator Cruz.
Mr. Chairman, I've got 3 different amendments that I want to call up. As the chair knows, I am a strong supporter of criminal justice reform, and in the 9 years I've served on this committee, we have had these debates back and forth. There have been times when the chairman and I have been side by side with criminal justice reform and proposing it together, and there have been times when we have been opposing each other. And for me, the distinction has really been on 2 criteria. Number 1, the criterion that Senator Cornyn just raised, and I commend Senator Cornyn for the amendment he introduced. I think it was a good amendment, which is the retroactive application of sentencing reform. And the problem with that, and this is reminiscent of some of the comments Senator Whitehouse raised with the previous bill, is as a practical matter when prosecutors are bringing cases against a criminal defendant and there's a whole array of conduct that can potentially be charged. When a plea agreement is reached, it is not uncommon for a prosecutor to reach a plea agreement on some of the lower charges and not prosecute the more serious charges if the plea agreement gets a sufficiently serious prison sentence that the prosecutor feels he or she is justifying their obligation to the public. The danger of retroactive sentencing reform is that you can have what on its face appears to be a nonviolent conviction that was in fact a violent episode, but the prosecutor accepted a plea deal because there was a sufficient prison term to be justified given the conduct. And going back retroactively risks undoing the bargain that was reached. Prospectively is very different. If a prosecutor knows what the rules are that will attach to any given sentence, then the prosecutor can make a judgment in terms of what pleas to accept and what pleas not to accept. So that's one area I've had long concern. A second area of concern, and I would say an even greater area of concern, is violent crime. For me, there is a qualitative difference, a line in the sand between violent crime and nonviolent crime. The reason I have been supportive of multiple efforts at criminal justice reform is that I do agree with nonviolent offenses, particularly nonviolent drug possession offenses, that our criminal law had sentenced too many defendants to overly long sentences not justified by the conduct. I think it's fundamentally different when someone engages in a crime of violence. Many of us on this committee have worked in law enforcement. I have spoken with parents whose children were raped and murdered by vicious criminals, and I have no desire to speak with any parent in that circumstance again and to be remotely responsible for releasing the rapist or murderer that committed that horrific crime. I view crimes of violence as qualitatively different. I would point out on the First Step Act, as this committee has considered various versions, initially when I got here, I co-sponsored with the chairman versions of criminal justice reform. Then the legislation got broader to encompass violent crimes. I stopped supporting it. We had markups in this committee where I introduced amendments to carve out violent crime, and the committee rejected my amendments. And I remember sitting in this room saying, there are the votes to reject these amendments on the committee, but if the amendments are not adopted, this will never pass the full Senate. It turned out that prediction was exactly right, that the amendments were rejected in committee, and then they didn't pass the full Senate. When the First Step Act was adopted, as the chairman will recall well, I was one of the last senators to get on board with the legislation, and I had a very explicit price, a series of amendments carving out violent crime so we would not be releasing violent criminals early. And the chairman ultimately agreed to those amendments. I supported the bill, and just days later, the Senate took it up, passed it, and a number of us were at the signing ceremony in the Oval Office shortly thereafter. So I think criminal justice reform is important, but I don't think we should be in the business of releasing violent criminals early. In the spirit of those sentiments, I want to call up initially Amendment ALB 21901. This amendment strikes the section of the bill that allows judges to waive mandatory minimum sentences for repeat offenders. The law already allows judges to sentence drug offenders without regard to the statutory mandatory minimum if the offender meets certain objective criteria, including that they have not more than 4 criminal history points. Criminal history points that are a fair and objective and consistent measure of the severity of an offender's criminal history based on their prior convictions. Section 102 of the First Step Implementation Act would allow judges to disregard this objective measure of criminal history in order to impose a sentence below the statutory mandatory minimum based on their personal view of the seriousness of the offender's prior criminal activity. I think this is, in effect, an end run around the mandatory minimums, and it is likely to lead to the very sentencing disparities that specific and objective criteria are designed to oppose. And so I urge a yes vote on the amendment and ask for a roll call vote.
Let me make sure it's clear which amendment you're offering. This is ALB 21901 relating to the safety valve?
Yes.
Okay. I'd like to respond then to what the senator from Texas has said. Let me start off from the beginning for those who are new to this conversation. We decided that the war on drugs needed to be re-examined because it didn't work. It didn't work. It didn't reduce the use of drugs. It didn't reduce the supply of drugs on the street. It filled the prisons, literally, to record-breaking numbers, primarily with minority defendants. And by the tens of thousands, they languished, many of them not just for years, but for decades. And we decided that putting mandatory minimum sentencing into this category of nonviolent drug offenders was fundamentally wrong and unjust, and we stepped out to try to change it. That's what it was all about. That cause grew in momentum to the point where it included not only the usual suspects on the liberal side, but even on the conservative side, where they said this just isn't fair. We're sentencing people way beyond what should be the case, and it isn't really fair to them, nor is it making America a safer place. That debate encompassed so many different people. I found myself in company of the Koch brothers, for goodness sakes, who were agreeing with us on this, and ultimately signed into law by President Donald Trump. So here we had Democrats and Republicans finally saying mandatory minimum sentencing should not be the case when it comes to certain categories of drug offenses. But we said, if you are a person who has been sentenced, this isn't automatic. You have to plead your case. You, the criminal defendant, have to come forward and make your case of why your sentencing should be reduced. Have you ever been involved in any of these cases when someone decides that they're going to try to get their sentence reduced under the First Step Act? This is not a matter of filing a piece of paper. I can recall cases in Illinois where they went to the prosecutors and asked them if they thought this was fair to reduce the sentence of an individual. They went to the judge, the sentencing judge. They went to the victims. They really did due diligence to make sure that they'd asked every question and understood where justice ended up. It was not an easy task for people to get that result. And so we have done with this bill, underlying bill, is to make this retroactive so that a criminal defendant can get into this process and try to get their sentence reduced. Senator Cruz has a different point of view. He believes, I think, that we ought to have hard guidelines, as we did with mandatory minimum sentencing, when it comes to situations. And this is involved. His amendment strikes the safety valve provision of the bill. The federal safety valve allows a judge to sentence below a mandatory minimum for a low-level nonviolent drug offense if the defendant meets certain requirements, including cooperating with the government and having a specifically defined limited criminal history. This First Step Implementation Act would allow a judge to apply the safety valve if the defendant meets all other safety valve requirements and the court finds the criminal history substantially overrepresents the seriousness of the case. The defendant has to go through the whole process of making his case about resentencing. The judge has to be convinced of this. It's an individualized case. I think that is what we had in mind with the original First Step Act. Senator Cruz disagrees. I hope we will defeat his amendment. Is there any further conversation on Nick Cruz's
Yeah, I
amendment?
want to speak on it.
Senator Grassley.
The First Step Implementation Act provisions on the safety valve, I think, simply give judges more discretion to determine if a defendant's criminal history warrants a mandatory sentence. Safety valves are meant to increase opportunities for individual assessment, not release dangerous individuals into society. So, consistent with existing law, a judge cannot apply the safety valve unless the defendant has fully cooperated with law enforcement and has not used or threatened to use violence or firearm caused death or serious bodily injury, and was an organizer, leader, manager, or supervisor of others in connection with offense. So I think that this goes well beyond what we had in a compromise on the First Step Act, and I'm going to vote no. There's several of my Republican amendments that I was going to vote for. I thought Senator Cornyn, I agree with him that violence is important to avoid, but his amendment was too broad, and I voted against it. I prefer Cornyn's amendment on just 924C defendants. There was another Cruz amendment I was going to vote for, but I can't vote for this one.
Senator Lee.
Just want to clarify once again, this amendment deals not with whether or not we're going to give relief to those convicted of serious violent felonies. In fact, so the sole purpose of this amendment is to strike Section 102. Section 102 specifically excludes from this safety valve serious drug felonies and serious violent felonies. So this isn't about whether or not you want to provide relief to those categories of offenders. That's off the table. All Section 102 is doing, and Section 102 is the one provision stricken by this amendment, this is just expanding the universe of cases in which it can be applied based on the defendant's criminal history. In other words, there are pretty rigid restrictions currently on how many criminal history points an offender may have if the judge is to invoke the safety valve. And so that's all this does. We're just talking about a mild expansion of the criminal history eligibility of an offender. It doesn't have anything to do with serious violent felonies, which are excluded. So I oppose the amendment.
Mr. Chairman. I will say my friend Senator Lee is right that this amendment is not focused on the question of violent crime as my next two amendments are, and so I look forward to Senator Grassley voting for the next two that come up after this. But this is focused on repeat offenders, on career criminals that commit offenses over and over again. And I will point out, any time in sentencing, federal sentencing law, state sentencing law has over the decades careened between two poles. On one pole is wide and sometimes unlimited discretion for judges to set a sentence. The downside of that is you end up with wildly unfair disparities depending on what kind of judge you get. You get a hanging judge, you get a terribly high sentence. You get a nice judge, you get a very limited sentence. And so the reason Congress came in and passed the entire guidelines is to say we should have some uniformity. It's not right that two defendants who committed the same crime should have such wildly different sentences when the underlying facts are quite similar. Now, the law then is careened the other way, which is very rigid mandatory minimums and strict requirements. That has the benefit of uniformity and predictability, but it also has the downside of sometimes having unfair instances because it is less able to respond to the extraordinary instance. And I think we got to have a balance between the two. It is why I have supported multiple times criminal justice reform relieving mandatory minimums, because I do think they can be unfair. I will point out enhancing the discretion of individual sentencing judges has some downside, and even more downside if the judges tend to skew one way or another. And we're sitting here 6 months into the new Biden administration. One thing that is quite striking is that every single Court of Appeals nominee President Biden has put forward, with the exception of the Federal Circuit that we've considered, 100% of them have been federal public defenders in their career. As this committee knows, a lot of judges sometimes are prosecutors, sometimes are public defenders. It is striking that in a criminal justice case you've got two sides, and right now all of the Biden Court of Appeals judges are from one side, the federal public defender side. Now look, a good judge is supposed to follow the law regardless of the sides, but enhancing discretion, if you have a bunch of judges who naturally side with the criminal defendant, enhancing that discretion to ignore objective criminal history criteria, I think is ill-advised.
I might just add for the record, we noted at yesterday's hearing of 50 federal circuit judges, 2 have a history of being public defenders. So President Biden has made it clear he wants to bring some balance to the circuit courts, and I don't think he has concealed that in any way. That's the way he feels, and I happen to agree with him. Pending before us is the Cruz Amendment, and I want to make sure I have the right number. ALB 21901. Any further discussion? Want a roll call, Senator? Clerk will call the roll.
Mr. Leahy?
No.
Mrs. Feinstein? No. Mr. Whitehouse?
No.
Ms. Klobuchar? No. Mr. Coons? No. Mr. Blumenthal? No. Ms. Hirono? No. Mr. Booker? No. Mr. Padilla? No. Mr. Ossoff? No. Mr. Grassley?
No.
Mr. Graham?
Aye. By
Mr.
proxy.
Mr. Cornick?
Aye.
Mr. Lee? No. Mr. Cruz? Aye. Mr. Stas?
Aye by proxy.
Mr. Hawley? Aye. Mr. Cotton?
Aye by proxy.
Mr. Kennedy?
Aye by proxy.
Mr. Tillis?
Pass.
Miss-
Aye.
Tell us pass it.
Mrs. Blackburn?
Aye by proxy.
Chair Durbin?
No. So I thought his thumb up, and I thought he was for Blackburn.
Chair Durbin, the votes are 7 yeas, 14 nays, and 1 pass.
The amendment is not agreed to. Any further amendments? Senator Cruz.
Mr. Chairman, I call up Amendment ALB 21988. This amendment clarifies that juvenile criminals who are tried as adults and who receive long sentences have to serve the vast majority of their sentences. The First Step Implementation Act allows criminals who committed their crimes as juveniles to be released early if they've served 20 years of their sentence. Now, 20 years is a long time, but it is nowhere near sufficient if a person has committed crimes so serious, crimes like murder, child sex abuse, or similarly heinous crimes, that he was not only charged as an adult, but was sentenced to 30 to 40 to 50 or more years in prison. When you have a prison sentence that long, it is because the crime of which that individual was convicted is extraordinarily serious. This bill makes clear that if a person, even a juvenile, commits a serious crime, they should do serious time. And that's why my amendment prevents individuals from receiving early release unless they've served at least 80% of the time to which they were sentenced, so that you do not have an instance of someone committing a horrific crime, being sentenced for a very long time, and then being let out early. And I would point out someone who is a juvenile who, say, was 16 or 17 when they committed the crime, 20 years has them being released at 36 or 37, and in the case of an extraordinarily violent defendant, a 36 or 37-year-old who has 20 years in prison, has a very high likelihood of coming out and committing another horrific crime of violence and just perpetuating the cycle. And so I urge a yes vote on this amendment, and I ask for a roll call vote.
Mr. Chairman.
Senator Leahy.
Mr. Chairman, in my years as a prosecutor, I asked for a lot of tough sentences, and especially if it's a violent crime, I always ask for them, and I tried a lot of those cases myself. But I also felt that the ultimate decision was not that of the prosecution, it was that of the judge. And I found that while I may have had some times where I disagree with the judge, I'm absolutely convinced I was then, I am today, that so much of this should be in the judicial discretion, and we should not be cutting that. I will oppose the amendment.
Thank you, Senator Leahy.
Mr. Chairman?
Senator Booker.
Yeah, again, I really appreciate the depth and substance of this conversation. I just want to point out that, this is a bill that really takes into account after that person has spent the majority of their lives in prison. And we know psychological studies show that the teenage brain is not fully developed. It leads to impulsive, immature decisions. Even the Supreme Court has recognized those mitigating factors. There is considerable things in this bill to protect against the concerns of society in terms of our safety. The person, the age of the defendant, the time of the offense, the report and recommendation of the Bureau of Prisons, that has to include whether the defendant has complied with all BOP rules and completed prison programming, a report and recommendation of the United States District Attorney in the district where the defendant was prosecuted, the victim's views. All of this has to be in there. I have spent a lot of time working with my colleagues on juvenile issues, including the banning of juvenile solitary confinement, which this committee did because, again, of the effect on those childhood brains. But the most moving testimony I've heard on this issue is from a colleague of many people here. I did not have the privilege of serving with Alan Simpson, but I just want to read his own commentary on issues like this. He says, and many people might know, that he committed some very serious crimes as a child. In his writing to the Supreme Court on issues of mercy for children, my list of childhood offenses is long. When I was a high school student in Cody, Wyoming, some of my friends went to old barrack structures. We set federal buildings on fire, torching them. I'm going to skip some of the other crimes he's talking about. I was lucky nobody was injured. My friends and I often played dangerous games with guns, shooting our shells off. They shot at people. I'm adding that now. I'm damn lucky no one was killed or seriously injured, his words. Still, that was not enough. My friends raised hell in the community, firing our weapons at road graders, killing a cow. Federal authorities caught us. He goes on to talking about attacking police officers physically. He was convicted. He was sentenced. But that was his teenage years. And he did not get a 20-year sentence. But, God, are we a country that thinks that children, even when they do heinous things, have no pathways to redemption after spending more than the totality of their life at the time of the crime in prison? God, this bill puts a very high hurdle for the evaluation of these young people. But the nation we live in recognizes that everybody here, and I don't mean to be so general, so maybe I'll just say for myself, like many young people I know, did stupid stuff, and thank God nobody got hurt. But sometimes people do, and it amounts to a very serious crime. I saw this in college. Are we a country that says that under no circumstances does that person have, after the majority of their life in prison, a pathway to redemption? I believe we are a nation that believes in those ideals, that everyone on God's earth deserves grace, mercy, and a pathway to redemption.
Thank you, Senator Booker. I would just add that I want to go back to where I started. This is not automatic. A person who is petitioning for a reconsideration of their sentence is embarking on a long, challenging journey, including those who are arrested as juvenile offenders. According to Senator Cruz's amendment, a juvenile offender could not be released before serving 80% of their sentence, even if they've already served 20 years. We took a survey in the Bureau of Prisons. Out of 150,000 prisoners, how many convicted juveniles might be eligible to petition under this process. 10. 10. I don't know the circumstances of those 10, but I want to make it clear, start to finish, this is not automatic. Petitioning for a reduction in sentence is not automatic. It begins a long, arduous process for a person to prove that they are not a danger to society any longer. It's a high bar. To automatically exclude them unless they serve 80%, I think, just defies the very purpose of the original Corrections Act and the First Step Act, and I would urge my colleagues to oppose the amendment. Anyone else seek to be heard at this point? Roll call. Clerk will call the roll.
Mr. Leahy?
No.
Mrs. Feinstein? No. Mr. Whitehouse? No. Ms. Klobuchar? No. Mr. Coons? No. Mr. Blumenthal? No. Ms. Hirono? No. Mr. Booker?
No.
Mr. Padilla?
No by proxy.
Mr. Ossoff? No. Mr. Grassley?
No.
Mr. Graham?
Aye, by proxy.
Mr. Cornyn? Aye. Mr. Lee? No. Mr. Cruz? Aye. Mr. Sass?
Aye, by proxy.
Mr. Hawley? Aye. Mr. Cotton?
Aye, by proxy.
Mr. Kennedy?
Aye, by proxy.
Mr. Tillis?
No by proxy.
Mrs. Blackburn?
Aye, by proxy.
Chair Durbin?
No.
Chair Durbin, the votes are 8 yeas, 14 nays.
The amendment is not agreed to. Any further amendments?
Mr. Chairman, I want to call up my third amendment. It is ALB 21923. And this may be the easiest of the three amendments I'm bringing up for members on both sides of the aisle to vote for.
We'll be the judge of that.
You will indeed. It was a Friday morning, May 18th, 2018. I was at home in Houston. Early in the morning, I got a call on my cell phone. I had been preparing to get on a plane and fly to an event, but I was told that just minutes earlier, there had been a shooting at the Santa Fe High School outside of Houston. Santa Fe High School is about 45 minutes away from my house. Instead of going to the events that I had planned that day, I got in a truck and I headed down to Santa Fe. I was at the high school a little over an hour after the shooting had occurred. A deranged killer had walked into that high school and had systematically executed students one after the other after the other. It was utterly horrific. I spent the rest of the day with students who were injured in the hospital, with students who had survived, with parents who didn't know if their loved ones, if their children were alive. One of the challenges with a mass shooting is it takes time to identify the victims. The agony of those parents as they sat there in a gymnasium wondering, is my son, is my daughter, which side of the ledger did they fall on? Law enforcement took several hours to identify the victims. I can tell you I was pressing law enforcement to give the parents a damn answer quickly, that the agony of not knowing was horrific. That mass murderer was a juvenile. He was a student who had committed that horrific crime of violence. He was apprehended. He was incarcerated. And as they were preparing to prosecute him, the state was preparing to bring capital murder charges. And the U.S. Attorney for the Southern District of Texas wanted to bring federal charges. Maine Justice was raising objections to bringing federal charges, a fact that I found deeply concerning because under the applicable state laws, this mass murderer would have been eligible under state law because capital punishment is off the table for juvenile offenders pursuant to the Supreme Court, would have been eligible for early release. I picked up the phone and called Attorney General Bill Barr. And I asked Bill to examine Maine Justice's objections to bringing federal charges. I believed on the merits. This deranged psychopath had committed clear federal charges, and under the federal guidelines, he could be convicted of long sentences that would ensure that he spends the rest of his life in jail. And I believe this monster should never breathe a breath of air in the free world again. There are crimes that are too horrific that they should not be released. I told Attorney General Barr, if DOJ did not change their position, that I intended to go to the floor of the Senate and make the case publicly, that I was hearing from the parents of the kids, why are the feds not bringing this case? Thankfully, Maine Justice reversed its position, said they would bring federal charges. At the end of the day, the Department of Justice ended up bringing 11 federal charges. Now, the murderer is still awaiting trial because he's confined to a mental institution, and he may not face trial. He may be confined to a mental institution for the rest of his life. But the bill before this committee would provide an avenue for a juvenile who has committed a horrific crime, who has committed a mass murder like what happened at Santa Fe High School, to be released early. I don't believe people who have committed the very worst crimes should be released early, and at least for me, I don't wish to be party to releasing any such violent criminals early. And so this amendment is narrow. It makes clear that individuals who are convicted and sentenced to prison for murder or for forcible rape are exempted from early release. And I urge members of this committee to vote yes on the amendment. And again, I ask for a roll call vote.
Thank you, Senator Cruz. I know all of us take our responsibilities before this committee home with us when we return to our states. I do too. And over the last several weeks, I've made a point of visiting with random members of the Chicago Police Department, public defenders, prosecutors, analysts to try to get a handle on crime in my state, particularly in the city of Chicago. I've met some amazing people who have given me insights which I could never gather just working in Washington. Last week was one. I went to a group that was doing advocacy work in the toughest neighborhoods of Chicago to try to reduce gun crime. They've had some success. They have a long way to go. But these amazing individuals have dedicated their lives to try to end gun violence on the streets of Chicago, and many times risk their lives to do it. One of them is very well known in Chicago. His name is Eddie Bocanegra. Eddie's well known because he's articulate, he's convincing, he goes into the neighborhoods in the toughest gang situations and brings peace to neighborhoods where otherwise people are going to get killed. Eddie knows what it means to be involved in violent crime. He was convicted of murder. Senator Cruz, he was convicted of murder when he was a teenager. And he served over 20 years in prison. When he was released, he's gone to the work that I've just described. There obviously was a purpose in his life that he never would have realized had he spent the rest of his natural life in prison. But someone took a chance on Eddie and believed that he deserved that chance, and he has proven, I think, over and over again every single day since that he understands the gravity of his crime, but he also understands the opportunity that's been given him to make this a better world. You've described someone who was involved in monstrous conduct. You use the word monster. I think that is an apt term. I don't believe that person, from where I sit, as you describe it, should be eligible. But I do believe that the process that we set up in the corrections bill, originally offered by Senators Cornyn and Whitehouse, for judges to take into consideration the reality of the person before them is a realistic standard. And to categorize all people in certain crime categories as ineligible, I think goes too far, and that's why I would oppose this amendment. Senator Booker?
I thank you. And again, I've gotten to know Senator Cruz well, and I know where his heart and his passion and his drive on these issues. I would reiterate what you said at the end, that horrific crime that's so shocking that he described, everybody in this committee sees horrific things like that for what they are. And this bill, as it stands, what we are doing here, will make sure that someone like that cannot meet this extraordinarily high bar. And so I share that spirit. I share that horror and that grief and that pain. But Senator Durbin, you described something that I know very well. I'm one of the few senators here that lives in a community where people are shot. Top of my block, a young man who I knew, watched grow up, got his head exploded by an assault rifle. Across the street from me, there was a shooting in front of a drug treatment center. I have seen too many kids, and this is where Ted Cruz is so on point, because it's often low-income and minority communities that are facing the horrors of this violence. And that's why I find it really incredible that the capacity for compassion and empathy, the understanding that we have brokenness, as Thomas Merton says, we're all collections of broken bones, that the wisdom in my community is profound. Because folk understand, as I've learned, going to too many funerals and meeting with the people that did these heinous crimes themselves, all the things that go into some of these children, from their lead paint poisoning, their child abuse, that doesn't excuse their murder and the decades they will get on their sentence. But what you said, Senator Durbin, really moved me. Because in my community, some of the most heroic men on the front lines of some of this violence that are stopping it, organizations like My Brother's Keeper, organizations in Newark like SOS, Save Ourselves, these are returning offenders back on the street trying to find a path of redemption. And these guys went away for murder. And they are now saving lives. And they are giving a testimony in our community that there are no throwaway people. Humanity is not disposable. So I know there are these mass murderers that, God, I would come forward and say they should never come out of prison. But in the brokenness of communities, where children are poisoned by toxins in their soil, in their air, where children face abuse, and then we in foster care systems see compounded abuse, where children witness violence at such an early age that when fireworks go off in some of our neighborhoods, they're diving for cover and showing signs of post-traumatic stress. When those children cross a line in our society and are sent to jail and stay there for decades and come out and show the truth of humanity and start saving lives, I know those people well as well. And I think they deserve some shot, high as a bar as it may be, that even though they did the most unimaginable, breaking one of the 10 commandments, that we still are a nation that believes people can find that path to redemption. So I pray my colleagues will think about those people, to know the person that Ted Cruz described will not come out, but the people that you and I know from Chicago to Newark, that we'll think about those people when we decide whether we're going to vote on this amendment, vote for this amendment. Thank you.
Mr. Chairman, my state isn't immune from this sort of violence that we're hearing about nationwide. Just this weekend, a juvenile in Davenport, Iowa, fired 80 rounds. Lucky nobody was shot, but probably people could have been hurt. I assume this amendment's intent is to make sure that juvenile parole eligibility isn't afforded to those who are in danger to the community. And I agree with that sentiment, and for that reason, I'm going to support this amendment.
Thank you, Senator. I've just been informed that the Council of Prison Locals, which represents correctional officers who work in BOP facilities, has just informed us this morning that they are endorsing the First Step Implementation Act provision on juvenile parole. They work with these inmates every day. Is there any further conversation or discussion of the Senator Leahy?
Chairman, I'll be brief. You know, it's very easy when you talk about a murder case of any kind to say, lock the door and never unlock it on the person. I think Senator Booker has eloquently pointed out some of the things behind it. I'm one of the few senators, and I served with 400 senators. I'm one of the very few who has gone to many murder scenes, often at 3 o'clock in the morning. First, as a 26-year-old prosecutor, I'd leave my home and my family and go to some of the most gruesome murder scenes. I'd prosecute the people involved. But one thing I learned is every one of them is different. Every one of them is different. From the murderer I prosecuted who had been paid to murder somebody, to another case as the victim was being carried to the hospital, somebody I'd known for years. I asked him, who did this? He shook his head no, and I said, please tell me who did this. He said, my son did, and died while I was holding his hand. Now, if anybody thinks one size fits all, it does not. Give the flexibility that this bill requires. Are the judges going to be right every single time? No. Are the prosecutors going to be right every single time? No. But one size does not fit all, and give the flexibility. Thank you.
Is there any further discussion on the Cruz amendment before us now? Roll call. The clerk will call the roll.
Mr. Leahy?
No.
Mrs. Feinstein? No. Mr. Whitehouse? No. Ms. Klobuchar? No. Mr. Coons?
No.
Mr. Blumenthal? No. Ms. Hirono? Mr. Booker? Mr. Padilla?
No by proxy.
Mr. Ossoff? Mr. Grassley?
Aye.
Mr. Graham?
Aye by proxy.
Mr. Corning? Mr. Lee? Mr. Cruz? Mr. Sass?
Aye by proxy.
Mr. Hawley? Mr. Cotton?
Aye by proxy.
Mr. Kennedy?
Aye by proxy.
Mr. Tillis?
Aye by proxy.
Mrs. Blackburn?
Aye by proxy.
Chair Durbin?
No.
Chair Durbin, the votes are 11 yeas, 11 nays.
The amendment is not agreed to. Are there further amendments?
Mr. Chairman,
Senator Cruz?
I'd like to make two comments. Number one, there's an old saying that those who fail to learn from history are doomed to repeat it. Unfortunately, it does not appear this committee has learned from that saying. Across the country, there are advocates of criminal justice reform who are watching what's happening here today. And they may well celebrate in a few minutes when your bill is getting ready to pass out of committee. But unfortunately, we're repeating exactly the same pattern this committee has done before. In a prior Congress, I introduced a series of amendments on a prior iteration of First Step to eliminate retroactivity and to exclude violent crimes. And the same thing happened then that happened here today, which is the committee voted it down. Then, as now, there was a majority on the Judiciary Committee to vote down every one of those amendments. You get all the Democrats and a couple of Republicans, that's enough to vote them down. And what I predicted then, in this room, I said, well, you can vote it out of committee, but what you've just done is killed this bill. There's some members of this committee that are relatively new to the Senate. This bill will be voted out, and the chances that it passes on the floor of the Senate right now, having rejected all three of those amendments, I can quantify with exact precision. The chances that this bill passes into law are 0.0%. And most of the members of the committee know that. Certainly the senior members who've been around here for a while know it's not going to get the votes to pass on the floor. So it may feel good as a partisan exercise to vote down all the amendments, but for the advocates of criminal justice reform at home, what you've just seen is the process failing because the bill won't pass. And both sides know that. Let me make a second point. We are in polarized times. We're in angry times. Each side yells and screams at each other. There's too much hate on both sides of the aisle. We're convinced the other side is always in the wrong. I hope that that fever breaks in time. Donald Trump was a unique president. Unique in good respects and unique in some respects that were not so good. One of the consequences of Donald Trump is that he drove our Democratic colleagues stark raving mad. And we are living in a world where congressional Democrats have been radicalized by 4 years of Donald Trump. There used to be such a creature as moderate Democrats. I'm not convinced there is such a thing anymore. In the last 5 months of the Biden administration with Schumer and Pelosi leading Congress, Senate Democrats have 3 times had votes to determine where they are on the question of violent criminals, on the question of the very worst violent criminals, murderers, rapists, child molesters. And the only reasonable conclusion an objective observer can derive from what we've seen the last 5 months is Senate Democrats have made the decision that they are the party that supports violent criminals. Why do I say that? Because on the floor, when I introduced an amendment to say we should not send stimulus checks, $1,400 checks from the taxpayers to criminals currently incarcerated, to murderers, to rapists, and child molesters, every single Democrat voted no. It failed by 1 vote. That means every Democrat was the deciding vote, and the federal government sent millions of dollars to criminals currently incarcerated, many for horrific crimes. Likewise, in the Rules Committee, I had a series of amendments to strike from S1, what many are calling the Corrupt Politicians Act, the provisions to mandate that criminals and felons be allowed to vote, and in particular focused on murderers, rapists, and child molesters. And once again, you saw Senate Democrats line up over and over and over again to say they wanted to strike down the state laws that prohibit the very worst criminals from being able to vote. And now today, we're not even talking about sending money to criminals. We're not even talking about letting criminals vote. We're talking about mass murderers and rapists. Do you let them out early? I guarantee you, every one of you, if you went home to your states, even in very blue states like Illinois, your constituents would be quite astonished that not a single Democrat on this committee is willing to say, let's not let mass murderers out early. That does not reflect moderation. In most prior Senates, there would have been some Democrats who say, well, okay, excluding murderers, excluding rapists, maybe that has some merit. Let's find a middle ground. But post-Trump, today's Democrats don't do middle ground. That's unfortunate for criminal justice reform because, as I said, as a consequence of today's votes, we're getting ready to vote on this bill. It'll pass out of committee. You'll get all the Democrats, you'll get a couple of Republicans. And then, in all likelihood, it will never come up on the floor. If it comes up on the floor, it's not getting 60 votes. Doesn't have a prayer of getting 60 votes. First Step Act passed because for a brief moment, Senate Democrats were willing to find a middle ground and compromise, and in particular, accepted my amendments to exclude violent criminals. Unfortunately, that brief moment of reasonableness and common ground seems to have passed us. I think that is unfortunate for the Senate, and it's even more unfortunate for the country.
The senator from Texas reminds us of his view of the Democratic Party regularly. That's his right under the rules of the Senate and this committee. But I think if we reflect on what we are working on at this moment and have worked on in this committee, it defies his description. This bill, which he has condemned as some sort of a liberal trope, some departure of radical left Democrats, the bill has broad bipartisan support, including the American Conservative Union, Freedom Works, law enforcement leaders, Association of Prosecuting Attorneys Leadership Conference, and many more. The bill that we are extending and making retroactive was signed into law originally by Donald Trump. It was supported across the board by the Koch brothers, as I mentioned earlier, many conservative leaders, and the reason was basic. We believe that we can do a better job of making Americans safe by having a different standard when it comes to justice and incarceration. Senator Cruz disagrees. That is his right to disagree. But I think when we look at the evidence of the incarceration rates in the United States of America, at least the Senate Judiciary Committee, not only has the right, has the responsibility to ask what is going on in America. Why are we filling the prisons more than any other country on earth? Are we that violent? Are we that criminal in our intent and our conduct to expect this to be normal? And are people in prison who frankly have been there too long or never should have been there? We know what's happened with videotapes and DNA. Innocence projects across America are finding people who are sitting on death row for decades were actually innocent, were wrongly prosecuted. Should we care? If you believe in justice, you should. What this bill has basically said was, we are giving some prisoners the right to petition for an opportunity for resentencing. Only an opportunity, no guarantee, and some of them don't have a ghost of a chance of ever seeing that happen. But for some, it will bring real justice. I want to be party to that. I'm ready to take the risk that others, like Senator Cruz, will criticize me for being soft on crime. That goes with the territory, I think, serving on the Senate Judiciary Committee. In the middle of this debate, to have the Council of Prison Locals, the correctional officers in BOP facilities informing us that they endorse our efforts to pass this law, these are the men and women who risk their lives every day in these prisons. They believe that what we're doing is reasonable. So at this point, at the urging of Senator Grassley, the clerk will call the roll on the passage of the bill.
Mr. Chairman? Mr. Chairman?
Excuse
Chairman?
me, I'm
Forgive me.
sorry. Senator Ossoff seeks recognition.
Just a brief reflection. The senator from Texas opened his remarks bemoaning the bitter partisanship that's infected the culture of this institution. I believe, Senator Cruz, that you offered the amendment that was just narrowly defeated in good faith. I believe you made meritorious arguments in advocating for it. I weighed it carefully, listened carefully to the debate, complex issues involving the prospects of redemption for juvenile offenders, and made my decision in good faith. And I want to note the irony that after bemoaning the partisanship and the culture of division and mistrust that's infected this institution. My friend, the senator from Texas, then launched into a partisan diatribe impugning the motives and integrity of his colleagues who came to a different view. Now, I'm new to this body, and I recognize that long tenure here and long careers in politics can jade and make cynical all of us who participate in the process of making very difficult decisions about weighty subjects with serious implications for people's lives. But I hope that as the senator from Texas and I continue to build a relationship, and as we all work together to try to advance the cause of justice in this country, that we can cease to presume the worst motives and partisan intent and recognize that we may come to different views on these issues in good faith. And I yield.
Mr. Chairman.
Senator Grassley asks unanimous consent to enter a statement in the record without objection.
Mr. Chairman, a brief comment in response. I thank the senator from Georgia for his comments. I would note that in my remarks, I don't believe I did impugn the motives or character of Senate Democrats. Rather, I focused on 3 specific issues that I raised before this body for a vote, and the votes that were taken. Votes are different from motives. They are objective actions. And I believe the votes that Senate Democrats have taken, repeatedly sending money to murderers, rapists, and child molesters, striking down laws that prohibit murderers, rapists, and child molesters from voting, and now voting for legislation to release from prison early murderers, rapists, and child molesters. I believe those votes are objectively extreme and radical. The only, as best I can recall, the only thing I remotely said about motives was I did acknowledge that President Trump drove Senate Democrats crazy. I don't think that's a terribly objectionable observation. I suspect many folks on both sides of the aisle would agree with that observation. I hope Senate Democrats behave differently, but there is a difference between impugning motives and pointing to clear, objective votes that I promise you, if you were to ask the voters in your states, and even the bluest states here, should we send money to murderers, rapists, and child molesters? Should we strike down laws prohibiting murderers, rapists, and child molesters from voting? And should we release from jail early murderers, rapists, and child molesters? I guarantee you 80% of your constituents in every one of your states would say hell no to all 3 of those. And so those, I believe, are objectively extreme votes. And I hope that pattern of voting, I hope that changes.
Clerk will call the roll.
Mrs. Feinstein.
It's on passage.
Final passage. Final passage.
On final passage.
Yes.
Aye.
Mr. Whitehouse. Aye. Ms. Klobuchar. Mr. Coons. Aye. Mr. Blumenthal. Aye. Ms. Hirono. Mr. Booker. Aye. Mr. Padilla. Aye. Mr. Ossoff.
Aye.
Mr. Grassley.
Aye.
Mr. Graham.
No by proxy.
Mr.
Oh,
Cornyn.
I'm sorry, no by proxy.
No by proxy.
Yeah.
Mr. Lee. Mr. Cruz.
No.
Mr. Sass.
No by proxy.
Mr. Hawley. Mr. Clark.
No by proxy.
Mr. Kennedy.
No by proxy.
Mr. Tillis.
No by proxy.
Mrs. Blackburn.
No by proxy.
Chair Durbin.
Aye.
Chair Durbin, the votes are 13 yeas, 9 nays.
The bill will be favorably reported to the floor. I want to thank the members of the committee for the early morning session, and I think we accomplished quite a bit together. If no one else seeks recognition, the meeting stands adjourned.